Okay, so to keep our stress level high enough, we're gonna move to the next panel right now. So we have a panel now on decision-making support and substituted judgment. And our speakers, I will introduce them all at once so we don't have disruptions. We will begin with Professor Rebecca Diller, who will speak about decision-making support in the dementia context beyond agreements. Professor Diller is a clinical professor of law at the Benjamin N. Cardozo School of Law. Professor Diller co-directs the Tzedek Civil Litigation Clinic, which represents older adults and persons with disabilities in a variety of matters. These include restoration of rights for people under guardianship, consumer matters, public benefit claims, and disability discrimination cases. Professor Diller has previously served as Deputy Director of the Justice Program at NYU's Brennan Center for Justice, Director of the Reproductive Rights Project at the New York Civil Liberties Union, and staff attorney at Housing Works and Legal Services for the Elderly in Queens. Professor Diller has testified before committees in both houses of Congress, and her work has been featured in the New York Times, USA Today, the Daily News, and many other media outlets. James Toomey will speak about authentic substituted judgment. James Toomey is an assistant professor of law at the Elizabeth Haub School of Law at Pace University, where he writes about bioethics and private law theory. His scholarship has been published in some of the best law journals in the country, such as the Virginia Law Review, the Washington University Law Review, the Indiana Law Journal, and the North Carolina Law Review. Before joining the faculty at Pace, Professor Toomey was a fellow and lecturer at Harvard Law School. Megan Wright is going to speak about planning for cognitive decline, combining formal supported decision-making and power of attorney. Megan Wright is a professor of law, medicine, sociology, and bioethics at the Pennsylvania State University. She's also a visiting lecturer in law at Yale Law School and an adjunct assistant professor of medical ethics in medicine at Weill Cornell Medical College. Professor Wright is a prolific author and sought-after speaker. I see her at many conferences, and we are delighted that she could join our conference today. So maybe let's be here, and I'll hold it.
Good morning. Great to see everyone. So my talk is going to focus on the development of supported decision-making as an alternative to adult guardianship, and the ways in which we might adjust the concept to better address the context and concerns of older adults living with dementia. How many people have heard of supported decision-making? Okay, so I'm not going to, though I am a law professor, I'm not going to call on anyone to explain it, but it's just helpful to know. So I'll sort of give a little bit of background on the concept. There's no one definition of supported decision-making, but in general, it refers to a process where people with disabilities work with family, friends, professionals, and others whom they trust to help them understand situations and choices that they face, ask questions, receive explanations in language that they understand, and communicate those decisions to others. So to some extent, it's a very broad concept, and it could be so broad as to incorporate things we all do every day, which is seek advice when we make decisions. But on the other hand, it's developed into a particular legal concept, which is a recognized process that can be an alternative to being placed under adult guardianship where you lose decision-making rights. As I'll describe in a minute, One of the ways in which we've seen the law address this concept is that state legislatures around the country have passed legislation to recognize particular forms of supported decision-making agreements, which we'll talk about more a little bit later. So just a bit of background on how I come at this issue. I do co-direct a law school clinic that focuses on the rights of older adults and people with disabilities. And in our practice, we've represented a number of older adults who are under guardianship, who were not very well served by their guardians. And also, to my mind, were not very well served by being under guardianship in general. And it was my sense that many of my clients had sort of fallen into guardianship, not because of a flaw exactly in their decision-making abilities, but because they had encountered some kind of crisis in their lives, some kind of crisis regarding finances, housing, social services, healthcare. But it wasn't so much what the law was telling me it was about, which was a decision-making assessment. It was really something else that was driving their ending up in guardianship. And so when I started hearing about this new concept called supported decision-making, which was coming on the scene as an alternative to guardianship, I was very intrigued, and I wanted to see if it was something that my clients might be able to benefit from. So I first, just trying to move the slide along.
It moved.
Oh, it really moved. Okay. So I first wrote about the topic just with a general call to think about the involvement of older persons in the development of supported decision-making, because up until that time, and this was 2016, and it's still largely the case, supported decision-making had mostly been used by people with intellectual and developmental disabilities as an alternative to guardianship, and it really hadn't taken hold in the older adult context. And then several years ago, I wrote another article with Morgan Whitlatch identifying particular potential and challenges for older persons and using supported decision-making. And so what I hope to do today is sort of push that work one step further to think about, okay, what are the actual policy developments that could enhance the ability of older persons to use this or to use a modified version of it. And in thinking about this, I want to approach the problem rather than thinking about it as how do we adopt this model that's developed in many states for the context of older people, but think about what the underlying goal of all this was. And the underlying goals are to really enhance autonomy, preserve dignity, and for older persons to avoid the imposition of guardianship based on cognitive decline whenever possible. And this is an important goal, preserving autonomy. Being stripped of decision-making erodes one's sense of personhood, identity, agency, dignity. As one article by a cognitive psychologist summed it up, being central to decision-making means I am still here, exclamation point, right? So it's really making decisions really does relate centrally to the idea of who one is and how one can direct one's life. And studies have shown that involvement in decision-making results in a better quality of life. So it's a goal I think we can all agree on. The big thorny question is how to get there and how far can we go with this concept. The right to make decisions is also recognized as a fundamental human right. Particularly in the UN Convention on the Rights of Persons with Disabilities, which goes back to 2008, and was very influential in sort of spreading the idea of supported decision-making around the world and in spurring advocates and activists to try to promote it here in the US. And so soon after this convention, the Robert Dinerstein, a law professor, provided the following frequently quoted definition of supported decision-making. And here he talks about it as a series of relationships, practices, arrangements, and agreements of more or less formality and intensity that are designed to assist an individual with a disability to make and communicate to others decisions about the individual's life. That's a very broad definition and a very broad concept. What I want to suggest is that as legislatures have sort of taken up this idea, they've really narrowed it in how they think about it, in that most of the legislation that we've seen that addresses supported decision-making has focused on recognizing particular forms of supported decision-making agreements. And Professor Wright is going to show you an example of one, which will help you see exactly how these agreements are structured. But these are basically agreements in which a person, a decision maker, designates a supporter or supporters to assist with gathering information, explaining options, and communicating decisions. And part of the reason that advocates have sought to get this type of legislation is that when the legislature recognizes a particular form of agreement, it can be quite helpful in persuading third parties like banks, healthcare institutions to recognize the decisions made with support by that decision maker. And so in that way, these laws have performed a sort of anti-discrimination function in that someone who might have their decisions questioned is able to, when the agreement is legally recognized, show that it was made pursuant to a legally recognized process. These laws and several others that deal with supported decision-making have also recognized it explicitly as a less restrictive alternative to guardianship. And while we don't have, a ton of data on what's happened with all the supported decision-making agreement laws, I think it is fair to say that they have, for the younger people with intellectual and developmental disabilities who've used this process, it's succeeded in sort of disrupting what normally we used to call the school to guardianship pipeline, which is my bad illustration on the left side of that slide. And that gets at the process that many younger people with intellectual and developmental disabilities, when they're aging out of the special education system, there had always been a tendency for educators and social workers to tell parents that the next step for them was to go get guardianship over their children. And by having these supported decision-making processes in law, that's sort of starting to change that, in that it's not necessarily going to be the next step. So that's sort of where we've gone with supported decision-making in a very short nutshell. But I think what's important to recognize is that while this school to the courthouse pipeline may have been disrupted, the pipeline or pipelines to the courthouse for older adults with dementia are quite varied and quite different and call for some different thinking. So here's a very inelegant representation of how an older person with dementia might end up in guardianship court, and that is in any number of ways, right? And there's not necessarily one typical trigger that could result in someone becoming subject to guardianship. What we see in the limited studies we have, and what I can confirm anecdotally from our practice is, that triggers for guardianship for an older adult with dementia tend to involve crises that overwhelm whatever planning the person has put in place. It could come from nursing home or hospitals trying to do discharge planning may seek guardianship. Nursing homes may seek guardianship because they're trying to get paid one way or another, or try to get the person to become eligible for Medicaid. So there's like lots of different ways that an older person with some cognitive impairments could become subject to guardianship. And what this means, I think, for the development of supported decision-making as an alternative is that we have to think about how do we address some of these pathways and how do we make sure that we're doing something more than just thinking about a supported decision-making agreement that could have some utility, but maybe of limited utility for the person retaining decision-making rights. So I'm going to move ahead. So there's some limitations of using supported decision-making in the dementia context that you don't see in the same way in the context they've been used most frequently, the intellectual and developmental disability context. So one is you have cognitive capacity that could be fluctuating and can in some cases decline rapidly. So if you arrive at an agreement about how you're going to make decisions with supporters, you might need to revisit that agreement quite frequently. You also have the concern that you have anytime you're thinking about supported decision-making that you really want to make sure the decisions are made by the person, not for the person, and you want to make sure there's sufficient mechanisms and procedures to ensure that that's really happening, that the person remains the decider. One of the biggest differences and challenges to my mind is that the agreements don't provide sort of case management and social services that the crisis that might give rise to guardianship frequently requires. And then another issue that I see is that we talk about decision-making, and when it comes to like something like finances or independent living, one can make lots of decisions. It's really the implementation of those decisions that requires ongoing assistance. So if we just focus on the moment of decision, we're not really getting at the range of supports that the person might need. And then there's what's been called the phenomenon of unbefriended aging adults, who are folks who have lost contacts with family and friends and don't necessarily have someone in their life already whom they can trust to designate as a supporter in an agreement. So I want to suggest that in light of some of these limitations, that we really think about augmenting the approach to support for older adults with cognitive decline with some other interventions. And so one is to think more about pressing institutions like healthcare institutions to accommodate impairments in decision-making. There's been a growing body of knowledge that's developed around things like cognitive prosthetics. How can we assist someone who has to make a tough decision? There are increasingly some studies about when you're seeking informed consent for a procedure, what are the actual techniques that can enhance capacity for someone suffering from cognitive decline? And so there's some literature on this, but it's not done. It's really not done. You know, think about how quickly we churn people through the medical system. Nobody takes the time that someone needs to really be able to process a decision. So that's one place where I think we could, in addition to thinking about supported decision-making more, you know, in the way that it's come to be understood, really think about accommodations for decisions in healthcare institutions. Then I think the other thing we need to think about is nesting this idea of support within broader guardianship diversion services. So things like, you know, good old-fashioned alternatives to guardianship, like bill paying assistance and financial management services. If we can integrate the idea of supporting decisions with ongoing support and implementing them, I think this model can be more successful in the dementia context. And then finally, and this is something Professor Wright is going to talk more about, integrating the idea of support with advanced directives. We do know that most adults with cognitive decline want to remain involved in decision making for as long as possible. They also might want to delegate some decisions, and we need more flexibility in our instruments to sort of accommodate the range of ways in which people want to retain control, yet plan for the future. We also know that, given the urgency of situations that can arise, advanced directives remain important. They may need to be activated in an urgent situation. You may need judicial approval of even, in what we call the one-shot guardianship, judicial approval of significant decisions. So there needs to be more thought about how to integrate these two concepts. So finally, I just want to end by noting that when supported decision-making developed as a concept, it really emerged out of activism around the rights of people with intellectual and developmental disabilities, and not out of activism from the dementia context. And so I think what's happened was we had a model take hold that necessarily didn't start with sort of the lived experience of people living with dementia. And as the model spreads, we really need to think about how we adjust it for this context. It has a lot to offer us, and the goal of retaining autonomy is an extremely important one, but we also have to think more broadly than the way legislatures so far have approached the issue. So thank you.
All right, good morning, everyone. Thank you, Professor Hoffman, for the invitation. It is great to be here this morning with you all. Today, I'm going to be talking about a topic, sort of a classic topic in the area of cognitive decline and the law, and that's the doctrine of substituted judgment in the context of proxy decision making. And my talk today will have 3 parts. First, I'll give a little bit of background. It will, of course, be familiar to many of you, but to situate what I'll be discussing, give a little bit of background. Then I want to share and talk a little bit about some data I collected in a study, along with some collaborators on ordinary people's intuitions in this area, which is currently under review. And then I'll transition to offer just some preliminary thoughts about what those data might mean for thinking about how substituted judgment operates in practice and how it might be designed. So, as I'm sure many of you know, right, the doctrine of substituted judgment is a doctrine that comes into play when you have an individual, often for reasons of cognitive decline, who's found to lack the legal capacity to make a particular decision. In this circumstance, the law must empower someone else to decide for them. And substituted judgment, right, is one alternative substantive sort of guide that can tell the proxy decision maker how they ought to decide, by what standard they ought to decide. And specifically, substituted judgment tells proxy decision makers to make the decision that this person for whom they're deciding would have made if they had capacity. Now, as a legal standard, right, we can imagine alternative standards that could guide proxy decision makers in different ways, but substituted judgment has become the prevailing one, at least overwhelmingly in the medical context, where it is most well established, most frequently litigated, has the most legal support. And my talk today will be focused on medical decision making, but it's perhaps worth noting that the idea of substituted judgment has, over the past 40 years or so, really expanded into a variety of contexts where we have proxy decision makers deciding on behalf of another person, including guardianships, conservatorships, decision making in that domain, the property domain as well. And the other thing I want to sort of flag on the front end about substituted judgment to situate it here is that conceptually, theoretically, philosophically, and legally, the idea of substituted judgment is very much tied up with the idea of advanced decision-making, and in particular, the enforceability of advanced decision-making documents like advanced directives. As we can talk about, right, one of the long-standing challenges to substituted judgment as a doctrine has been a set of evidentiary concerns that it really is hard to figure out, what would this person have done if they had capacity? The evidence in this domain is rather mixed as to whether, even proxy decision makers who think they know quite well the person they're deciding for, how accurate those decisions are. And so, right, the law recognizes a number of mechanisms of advanced decision-making that have long been sort of part and parcel of a theoretical move towards the idea of substituted judgment, right? Advanced decision-making mechanisms are a way for a person, while they have sort of ordinary lifelong cognitive functioning, ordinary capacity, to tell us what they would want if they were to become incapacitated. And so if our legal goal is to make the decision that they would have made when they were capacitated, it makes sense to take sort of advanced decision-making documents as having great legal weight and maybe treated as binding, right, in all circumstances, because they are an expression of what this person wanted while they had ordinary cognitive functioning. In other words, there really is a way of thinking about the enforceability of mechanisms like advanced directives as an effort at getting at this underlying idea of substituted judgment, right? Advanced directives may be enforceable for the same reasons that we think substituted judgment is a good idea. But of course, for all its legal popularity and growth in sort of doctrine, substituted judgment has always been a controversial standard. It raises a number of quite difficult philosophical and practical challenges. On the one hand, in its favor, it appears to have pretty broad intuitive support. I have a previous study that showed in a population of older adults, about 2/3 of them thought that substituted judgment was the right way to decide on their behalf if they were to become incapacitated, right? Which is a large majority, but certainly not everyone. So there's broad intuitive support for it, but by no means universal. Similarly, sort of in favor of the substituted judgment idea, you've got many philosophers like Ronald Dworkin, who think that substituted judgment or something like it is the right way to make decisions in this context, the right way to respect the autonomy of persons. If you think of autonomy at kind of a broader level of this person's life or life story in some sense, and people like Dworkin think that's the right way to think about autonomy, right? The ability to sort of set the course of your life. On the other hand, there are a variety of arguments against substituted judgment as a standard, and perhaps the most powerful philosophically is the idea prominently associated with Rebecca Dresser and others that individuals with advanced dementia are no longer the same person that they were when capacitated and when giving us this evidence that we might apply in deciding on their behalf. And if that's the right way of thinking about it philosophically, it might make no sense to impose the capacitated decision-making of another person from the past on this person now. And another related critique here has to go with the ability of people to change their minds and our need to respect that, right? Especially insofar as the idea of substituted judgment takes prior writings or advanced directives as dispositive or highly probative of what this person would have wanted if capacitated. Even many years later, right, many years down the line, we might think that this doctrine locks in prior capacitated preferences over future changes of mind, even if those changes of mind really are sort of genuine or authentic, but are happening during someone's period of cognitive decline. So that's all by way of background. Recently, along with my co-authors, Jonathan Lewis, Ivar Hannakainen, and Brian Earp at University of Manchester, University of Granada, and Oxford, respectively, we conducted a study on ordinary people's attitudes in this area that, at least for me, complicates to some extent how we might think about the goal of substituted judgment. In the study, we presented participants with a vignette in which an individual's expressed preference after cognitive decline. So they've lost a lot of cognitive function, but they are capable now of expressing a medical treatment preference, and they do, but it directly contradicts a preference they had expressed years prior with ordinary cognitive functioning. And we presented some participants with this vignette framed in the first person, and some participants with the vignette framed in the third person, either for someone they're close to socially or a total stranger. So we were trying to see how people decide for themselves in the future what they think the right standard is versus for other people. Now, the headline finding here, the one framed in the paper currently under review, is that participants were significantly more likely to follow a preference expressed after substantial cognitive decline when they're thinking about a third party rather than they're thinking about themselves. When they're deciding for their hypothetical future self, participants were significantly more likely to insist on their prior, current, lifetime treatment preference over future contrary preferences. So there's a lot interesting going on with that. But today I want to focus on a somewhat subsidiary finding to that, which was that participants' views about whether the individual with cognitive decline was still their true self, which is a psychological construct psychologists are finding sort of useful, interesting in a variety of different contexts. And the intuition behind the idea of the true self is who this person is really deep down inside. But people's views about whether this future person with dementia was still their true self correlated with their medical treatment decisions in the future in the following way. If the participant thought that the individual with cognitive decline in the future was still their true self, they were more likely to follow the preference they expressed in the future, and vice versa. If a participant thought that the individual in the future was no longer their true self, they were more likely to insist on following the prior lifetime preference. What does this finding tell us about people's views about substituted judgment? I think a few things, and some of what I'm going to say also draws on the qualitative data we collected, which is not in this particular paper. We're working on a new qualitative paper at the moment. But one thing we can say here is that Dresser's concerns about someone with advanced dementia being a completely new person doesn't appear to have a lot of intuitive salience. Participants were perfectly happy to conclude that an incapacitated person after substantial cognitive decline, right, they may not be their true self, but, right, those people who conclude that this person in the future is not their true self are the same ones that insist on following the prior capacitated preference. So it seems that participants are not generally thinking that future individuals with cognitive decline are sort of an entirely new self with their own suite of decision-making prerogatives, but rather is connected in some normally significant way with their prior self, although this future self may not be true or authentic or genuine or expressing preferences that have a normative requirement of being followed, but rather think they want to help this individual, follow preferences that are more authentic to their true self. On the other hand, there is strong evidence that participants care about recognizing genuine changes of mind. Clearly, participants are comfortable with the idea that a true self can genuinely change its mind, and if it does, that changed position must be respected. We saw this among the large cohort of participants across cases who believe a future individual is in fact still their true self and follow that changed preference, even though it is contrary to a prior decision that is exactly the opposite, but made with full cognition. And in the qualitative responses, what we saw was many participants said just that. People change their mind, and we must follow that. So one way to interpret these findings is as revealing a concern for what might be thought of as the authenticity of decision-making or the compatibility of a decision with someone's true, authentic, real, genuine self. That is, participants might think that authentic decisions must be respected so long as they can be expressed almost regardless of the level of cognition with which those decisions are made. So participants who think that someone in the future is still their true self see that true self as making an authentic decision and they follow it. Whereas participants who think the person in the future is no longer their true self find that decision in the future somehow inauthentic and go with the prior one that they might think reflects the more authentic self. So now there's a lot of work here that's got to be done as to whether this is the right interpretation of the data. Some more empirical work to be done here for sure. And even if this is the right interpretation, we've got questions of the extent to which right, ordinary moral intuition should play any role in legal or ethical design here. But what I want to start talking a little bit about today is just a preliminary exploration of the implications of this idea of what really matters in this context is the authenticity of decision making, what the implications of that might be for substituted judgment. In other words, what might a doctrine of substituted judgment based on this idea of authenticity look like? First, and most straightforwardly, we might think of it as a rephrasing or really maybe just a clarification too, because to some extent, surely this idea is already implicit in substituted judgment, but the way that we phrase and talk about substituted judgment. And that would be to clarify that the standard is asking proxy decision makers or courts, whoever is making this decision, not necessarily to make the decision this person would have made if capacitated, but rather make the decision this person authentically, genuinely wants to make at this time, or the decision their sort of true self would make under these circumstances. The focus, in other words, might be not strictly speaking on the levels of cognitive functioning with which a decision is expressed now or in the past, but whether the decision is authentically this person's. In some cases, this might mean following a prior expressed wish made with full cognition. We might think in general, sort of lifetime decisions made with ordinary lifetime cognitive functioning might be more authentic than those after substantial cognitive decline. But in many cases, we would want to recognize that this might mean following sort of any kind of preference that can be expressed after substantial cognitive decline, so long as it can be discerned, so long as we think it is authentic or genuine, which our results clearly show that many people think is a possibility, right? People think that the true self can persist through substantial cognitive decline. And similarly, we might think in jurisdictions moving towards supported decision-making, this rephrasing might change how supported decision makers think of the goal, helping this person express their true self, make an authentic decision, as opposed to merely making one. Second, this clarification of the goal of substituted judgment would have to balance two intuitions, which can give us two practical takeaways about how the doctrine should aspire to function. The first intuition is that some preferences people express are clearly more authentic in the lay conception of authenticity than others, and correspondingly entitled to more deference. In other words, and it's quite clear from the results I presented, it isn't the case that people think that every preference that can be expressed in English must normatively be followed, but rather, right, certain genuine or authentic expressed preferences ought to be followed. Obviously, more research and theorizing is required here on sort of what the indicators or constituents of a more or less authentic decision are. But we can say preliminarily, on the one hand, it seems that there's a general intuition that decisions made with more cognition that are more reflective, more well thought through, etc., do tend to be thought of as more authentic. But on the other side, that change decisions can be thought of as authentic as well, so long as there's sort of reasonable responses to stimuli, reasonable changes over the lifespan. And then brings us to the second intuition here, which is that people clearly think that change decisions are compatible with authenticity. And people clearly think that this concept of the true self, whatever it is, genuinely can change its mind or change even its profound values over time. In other words, when we talk about the compatibility of a decision to a true self, people are not picturing the true self as some kind of set of fixed values or preferences over the lifespan that comprise a determinate true self over time. But rather, it's clear that people intuitively understand that an authentic, genuine self can change over time, even in very important values-driven life or death decisions. At the same time, it's also clear, right, that not all changes are thought of by ordinary people as genuine changes. They can be seen as deviations from the true self. And in those cases, participants are going to lean towards going with whatever prior decision the person had made. Now, what sorts of decisions are thought to be compatible with the true self and which are inauthentic may appear on its face somewhat mysterious and will definitely require more research and theorizing. But we can say, based on this data, right, any account of authenticity in substituted judgment must account for the intuition that many changes in decisions and values, etc., that people make are thought of as authentic and genuine and entitled to be followed, while others are not. And drawing that line is going to be an empirical and philosophical challenge. What do these intuitions mean from a practical perspective? I think two quick takeaways, neither of which is particularly radical. The first is that written instructions like advanced directives should be taken as weighty evidence but not binding on their face, especially if they were composed a long time ago. Again, not a radically new observation or position, but it is compatible with both of these intuitions about the authenticity of decision making. On the one hand, right, advanced directives, presumably made with full cognition, presumably thought through, entitled to some deference as an expression of this person's genuine decision making at the time they were written. On the other hand, especially if it's many years old, we know that it's possible this person has genuinely changed their mind, and so some discretion to move from that should be considered. And the older the document is, perhaps the less evidence on its face it should be taken as binding. Second, and finally, and again, not particularly radically, the theory of authentic substituted judgment suggests that there really is some benefit here to having proxy decision makers who are close friends and family with some built-in discretion. Now, of course, this is largely how substituted judgment functions today, but there's a lot of talk in the literature now about potentially having AI do substituted judgment, and perhaps our results suggest that there is some benefit to having someone who knows you closely do this. And why is that? Well, so long as the distinction between changes that are genuine and changes that are not remains at least somewhat mysterious, we might think that people who know you really well might have some intuitions that they can't really articulate or put down on paper about the conditions under which you would genuinely change your mind or not. And so there is some benefit there. We saw this a little bit in the data itself, right? We asked people about themselves, deciding for someone close to them and deciding for a stranger. The group deciding for their best friend or someone close to them looked different than people deciding for strangers, basically because they had more access to what they think makes up this person's true self, what sort of decision making is genuine or authentic to them, and the conditions under which that person might change their mind authentically, even if for many people that's hard to articulate and might be a little bit more intuitive. All right, so of course, there's a lot more to be said about all of this, but that is what I've got for all, you all this morning. Thank you again for having me, and I look forward to your questions.
So, hello, I'm really happy to be part of this very interesting panel. Thank you for great presentations. And thank you for the invitation to be part of this important conference. So the title of my talk, I've changed a little bit to be more consistent with the remarks that I prepared. It's planning for cognitive decline, combining formal supported decision-making agreements and advanced healthcare directives. So I'm looking at combining the documents themselves, in order to plan for cognitive decline. And so to that end, my remarks are going to be focused only on acquired cognitive disabilities, and in particular dementia, as opposed to intellectual or developmental disabilities. And we know that that's where sport decision-making arose from that particular community. So I'll start by discussing medical decision-making law very briefly because Professor Toomey did a great job about them. But I will talk about changes that I have proposed in past work for patients with dementia with respect to medical decision-making, in particular moving towards supported decision-making. And by the end of my remarks, I'll pose some questions about how supported decision-making agreements and advanced directive forms can be combined, mostly in the medical decision-making context, but time permitting, also beyond that decision-making context. So to start, I want to orient my remarks considering the foundational legal principle in medical decision-making law and ethics, which is respect for patient autonomy. So we know that competent adults, those of sound mind, are entitled to make their own healthcare decisions, including life-ending decisions and including decisions that go against medical advice. But capacity, sometimes called competence, is key to the contemporaneous exercise of this legal right. And there are lots of different definitions of capacity. So sometimes medical decision-making laws will describe it as the ability to make or communicate a decision. Clinicians, such as psychiatrists, may define it as the ability to communicate, understand, appreciate, and reason. And still others may add additional decision-making criteria, such as making decisions consistent with one's values, adding affective decision-making domains or criteria. Some might include the ability to retain information in their definitions of capacity. But we also know that if a patient lacks capacity, the law will facilitate respect for prior precedent autonomy by looking to advanced directives already discussed or a substitute decision maker. And because I'm going last, I don't have to spend any of my time talking about all of that now. So I'm going to move on and just say, Professor Toomey talked about some of the debates about advanced directives. So a lot of the court cases that contributed to the development of this area of law concern patients who lacked capacity because they were unconscious and would never regain consciousness. They were in the vegetative state. So think of Quinlan, Cruzan, and Shiva. Someone needs to decide for these individuals. But the situation becomes more complicated when you have a conscious patient who can communicate, at least somewhat, but has cognitive impairments that may lead others to question whether they have decision-making capacity and are thus able to exercise their autonomy contemporaneously. So I've spent some time thinking about this in the context of patients with dementia. And I've wondered whether our current medical decision-making laws actually are respectful of this patient's population autonomy, or whether law can do that. And in particular, in this work, I've asked whether persons with dementia should be legally entitled to make their own healthcare decisions at the time the decision must be made. And so for guidance, I turn to the lived experiences and decision-making preferences of persons with dementia instead of to arguments advanced by legal scholars or medical providers. And the thought is, if we look to what people with dementia actually want, and we modify our laws accordingly, we might be able to increase well-being for this population. So I'm going to show you just a few citations for studies of the healthcare decision-making preferences of persons with dementia. These studies consistently reveal that overall, people with mild dementia prefer to be involved in decisions about their lives rather than having others make decisions on their behalf. They know when they're in the early stages that their cognitive abilities are going to decline over time, but they want to remain independent and feel capable for as long as possible. They want to share in healthcare decision-making with their family members and physicians, but they also want others to respectfully provide support instead of taking over the decision-making process. And patients with dementia often convey frustration with not being acknowledged as having the capacity to think rationally and not having their current preferences respected. Unfortunately, despite evidence that persons with dementia prefer to participate in decision-making, many patients with dementia report unhappiness and dissatisfaction in their healthcare encounters. They report that once they're diagnosed with mild cognitive impairment or dementia, their healthcare providers no longer communicate with them and may not even tell them their diagnosis. Instead, clinicians will talk to family members to convey and collect information about the patient's experience with dementia. One patient with Alzheimer's disease reported, quote, "My doctor asks me how I am, nods when I tell him, and then asks me to step outside. He and my wife discuss me and then call me back and tell me what to do." Another patient noted, "People talk about me, around me, but don't talk to me." This exclusion from healthcare decision-making, even for minor or routine decisions, is contrary to the decision-making preferences of many persons with dementia and leads to feelings of marginalization and resentment towards their family members and physicians. Now, we might think that they're being excluded from making decisions because the dementia has progressed to the point that they're incapable of expressing what's important to them or making a choice. That is, they're failing on some part of our capacity assessment. But we have empirical evidence from social scientists that patients are excluded from healthcare decision-making even when they have capacity. One scholar observed that in some cases it appears that doctors were inclined to conclude that a patient lacked capacity simply because they had dementia. That is, there was this confusion about when doctors were looking at their patients' inability to manage independence and care, they were confusing that with incapacity or inability to make a decision. Indeed, sociological research has shown that the presumption of incapacity begins at the moment of a dementia diagnosis. So I'll direct you to this book. It was an ethnography watching healthcare providers deliver the diagnosis and immediately turning to the family members and stop talking to their patients with dementia. I'm going to skip over this quote, but it just says more of the same. In brief, the empirical literature demonstrates that persons with dementia do prefer to be actively involved in decisions that affect their lives, but are often marginalized, ignored, or excluded from the decision-making process, even in the early stages of dementia when significant cognitive abilities remain and they're capable of decision-making. So we know that the experience of healthcare decision-making does not accord with capabilities and preferences of many persons with mild and moderate dementia, and this leads to a decrease in their well-being. I also just want to note that if we leave the scholarly discussion of capacity and just use a lay determination definition, if research participants with Alzheimer's disease can say these things to researchers asking them about their preferences and experiences in this kind of language, I think that they are owed deference to the decisions that we might say that they have capacity and should be treated as competent adults. Okay, so knowledge of decision-making preferences and quality of life assessments, coupled with the fact that dementia, at least in its early stages, is not completely incapacitating, and often for a lengthy period of time is not, has led me to wonder whether the law can do better, provide better options for patients with dementia when it comes to medical decisions, rather than relying on advanced directives and surrogate decision-making. And I turn to supported decision-making, which again, thanks to a great presentation from Professor Diller, I don't have to explain to you what it is, so I'm going to skip over these slides. But I think supported decision-making can be a good option for helping facilitate the contemporaneous exercise of autonomy for this patient population. So in state laws that have recognized formal supported decision-making, what they do is they preserve the legal decision-making authority of a person with a disability rather than transferring that authority to a surrogate. Under this model, an adult with a disability, often referred to as principal, voluntarily chooses people to assist them in decision-making, their supporters, and may formalize the arrangement in a written agreement. And the supporter's role may include helping to gather information, thinking through the decision, and conveying the decision to others. So I am going to show you an example of such a form. This is a form that complies with Texas's supported decision-making legislation. Texas was an early adopter of this. So the form here starts with an explanation of what supported decision-making is. It also allows for customization for the adult with a disability to direct what domains that they like decision-making assistance with. It notes here that the decision maker is the adult with the disability. It is not the supporter. It also describes how the supporter may provide assistance. right below this, I don't have an animation for it, there's an information release, so they can release medical information or educational information. This is really important part, so the supporter consents to be a supporter, and that's reflected in this agreement as well. And then we have a warning. This is a warning to third parties if they suspect abuse, neglect, or exploitation, to contact the state, and also the duty of these third parties to rely on this agreement. So I actually want to pause on this slide for a moment to note that there is a little bit of a debate or conversation among scholars about what exactly in these supported decision-making laws entitles adults with cognitive impairments to make their own decisions. Is it the provision of decision-making support that increases capacity and thus makes the decision worthy of legal respect? Or is it the form itself that directs that the adult with the disability is presumed to have capacity, that they are the rightful decision maker instead of the supporter, and that they can make decisions in the absence of support? And I submit that it's both. So I've written about how supported decision-making can be a better option for individuals with mild to moderate dementia when it comes to medical decisions. And I have argued that despite cognitive impairments, these individuals retain the ability to articulate their values, assert their preferences, and choose between healthcare options, just as persons without dementia can. And if provided support, they can make decisions that align with their preferences, interests, and values. In brief, individuals with mild to moderate dementia can exercise their agency contemporaneously if they're not prevented from doing so by well-intentioned family members, physicians, or even medical decision-making laws. So I'll also note, and we've seen this already from the presentations, once a tool is available, it might be used in unexpected ways. So this was originally envisioned for people with intellectual and developmental disabilities to avoid guardianship. We're starting to discuss how it can be applied to different populations of people with cognitive impairments. I've also written a little bit about how it can be used for different kinds of perhaps unanticipated decisions. And in fact, how supported decision-making may allow individuals with decisional impairments to access medical aid in dying, which in the United States has a contemporaneous decisional capacity requirement. And I think that perhaps this possibility was not envisioned by state legislatures or disability rights advocates who push for supported decision-making legislation. But again, once a tool is available, we can use it in different contexts and for different kinds of populations. And as supported decision-making laws continue to be adopted, I submit that we need to think about other ways that they can be used and how they can be combined with other tools. So when I initially started writing in this area about dementia and supported decision-making, the reaction from the legal community tended to be that lawyers and law professors wanted to bind their own potentially future demented selves via advance directive, and in particular use advance directives to hasten their death in the event that they acquired dementia. And that's because the legal community really privileges autonomy, in particular our own autonomy, and cannot imagine living a dignified life if they are not autonomous. And we see this reflected perhaps a little bit in the results Professor Toomey talked about. But over time, I have noticed a shift in reaction from the legal community to some of this work. And last year at the ASLME Health Law Professors Conference, I was talking a little bit about supported decision-making, and I was asked if any states provided a combined supported decision-making agreement template with a healthcare power of attorney form. And so this is actually going to be the remainder of my presentation's focus. So my interlocutors were interested in planning for cognitive decline or their future incapacity by maintaining autonomy for as long as possible through supported decision-making, but also appointing someone to decide on their behalf if this became necessary. So in the case of planning for dementia, we can imagine that at some point in the progression of dementia, a person's not going to be able to make their own decisions, even if provided with support. Or we can imagine circumstances where they may need someone to come in and make a decision. Maybe they're receiving medical treatment, being sedated, they need a substitute decision maker. So we can contemplate that they would want both. When you're planning for cognitive decline, you might want both supporters and healthcare agents. So we can actually see this in the current generation, this is 2023 supported decision-making statute in California, where this most recent version of supported decision-making statutes does recognize that supported decision-making is just one type of planning or one mode of decision-making for people with disabilities, but others might include powers of attorney, advance directives, information releases, and so forth. And this is likely in recognition of the fact, and this is again coming from California's supported decision-making statute, that adults with disabilities are not solely those with intellectual developmental disabilities, but also with age-related disabilities, including dementia. So I just briefly want to show you, before I talk about combining these forms, we've seen the supported decision-making form. This is your most basic advance directive form, has a living will where you can consent to or refuse particular medical interventions in advance. And that last page there is appointing a healthcare proxy. I do want to note that you could, under this most basic form, appoint someone to be your agent, and they may never know about it until the hospital calls them and asks them to make a decision on your behalf, unlike with supported decision-making where the supporter consents. So when we think about combining these tools together, I don't know that states are currently providing templates. Oftentimes you can go to state websites and get a copy of the supported decision-making agreement template for states that have formal supported decision-making. You can also typically find a basic advance directive form on state websites. I don't know that states are yet providing these together, but you could imagine combining them, and maybe people are. Because these agreements are private, we don't actually know what's going on yet. We don't have good data on how they're being used in practice. So it's possible that people are currently, when planning for cognitive decline, completing all of this. But creating this tool and providing it to individuals does raise questions about how it might work in practice. So that's where I'm going to end with actually just a series of questions. So we might first just ask about who might be using this. We know that very few people complete advanced directives, advanced healthcare directives, about a third of older adults. We know that supported decision-making is really recent and most people don't know about it. And then most people are probably going to be thinking about it, not for themselves, but for other types of disabilities. So the total number of people who might actually want to use a combined tool might be really low. Might be something that only really sophisticated advanced planners might be interested in, like lawyers. But even with this pretty small group of people who might be interested in this, it doesn't mean it's not important to consider what it might, what the implications of creating and using this tool might be. A practical one might be, do we have a place to store this information in the healthcare system and electronic health records? Is there a place for doctors to note who patient supporters are? Even if there is, will they respect the supporter, or will they treat the supporter like a surrogate? But beyond these more practical questions, I'm going to leave you with some deeper questions to consider. One is, how do we know at what point in the trajectory for capacity to incapacity, assuming we have a gradual change, the substitute decision maker or the healthcare agent is going to be necessary? Or when we have fluctuating capacity, how do we know whether the person should be supported or whether there should be substitute decision making? What if the principal is conscious and able to communicate objections to findings of incapacity or substitute decision making? What if the person has chosen supporters who differ from their healthcare proxies? So these are different individuals. What if there's disagreements between these parties about determinations of capacity or the decisions that are being made? Who makes the determination of incapacity? Is it a supporter? Is it a healthcare agent? Is it the supported person or the adult with the disability? Is it a physician? We're assuming the physician's always there to tell you when someone has capacity or not, but that's not how this works in practice. How do all these parties work together? Does a supporter who is also a healthcare agent have the authority to change their designation from one to the other? So should someone else be overseeing this process? Will the supporter even understand their role? Will they think that they are entitled to make decisions? So those are just some things to consider, especially as supported decision-making laws continue to be adopted. So I do not have time to go into it, but we can imagine that formal supported decision-making permits can be combined with other types of power of attorney, financial power of attorney, more general powers of attorney, which raises its own set of issues. If you're interested in my work on supported decision-making, I'll point you to these articles, mostly about dementia and medical decision-making, but some about traumatic brain injury and some about human subjects research. All right, thank you.
Thank you so much. That was a wonderful panel, and I was going to ask all the questions that Professor Wright just asked herself, so I'll restrain myself. So we have one question online. Let's begin with that.
This person said, I manage the intake and referrals for guardianship services here in Cuyahoga County. How do we get medical providers and agencies on board with all of this, which I believe was in reference to the supported decision making? The biggest thing we hear is, well, they just need a guardian.
We don't have supported decision making here in Ohio.
What was the question?
Yeah. This person said, I manage the intake and referrals for guardianship services here in Cuyahoga County. How do we get medical providers and agencies on board with all of this in reference to supported decision making? The biggest thing we hear is, well, they just need a guardian.
And O'Mara, you say we do not have supported decision-making permitted in Ohio.
There's no legal support for it. There isn't legislation within Ohio for it.
So our ethics expert says there's no legislation. Does there need to be legislation?
I would say no, because already embodied, I don't know the Ohio guardianship statute off the top of my head, but in nearly every state guardianship law and as a matter of constitutional law, there's a requirement that you exhaust less restrictive alternatives. So if there is an opportunity to do supported decision-making as a less restrictive alternative, I think even without the magic words being in your statute right now, it's implied that it should be tried. But I think the harder question is the question that the person typed in, and I think it's a process. We've seen really a tremendous amount of change in just the last decade in people's views about this. And so I think it's partly an education and advocacy task, but I don't have a simple answer for her. I wish I did.
Anybody else on this? No. Yeah. Oh, sorry. Go right ahead.
This might be more of a comment than a question, but particularly the three of you and the question from the online audience makes me think of one time I was working with a hospital board doing some education about advanced directives. And one of the person in all sincerity said to me, who was on the hospital committee trying to help with advanced directives, said, we just need a billing code so that we can get these people to sign the documents. And I thought, oh, so wrong on two levels, but also kind of practical.
Can I just respond to this? So they have been saying, we just need a billing code, but then they don't use it. So they got the advanced care planning billing code, but we've not actually seen it being used.
So my question is whether the law can actually keep up with societal changes, or are we always going to be behind significantly? Because as the population is aging, we don't have the traditional nuclear family with support anymore. You have lots of individuals who are by themselves. In the medical profession, you don't have primary care physicians that follow people in depth. For somebody who's hospitalized, you have hospitalists who never have a baseline about a person because a primary care physician can't make rounds anymore. How can the law be proactive, or can it ever be?
Anyone want to take that one on? No. Somebody has to.
pointing to the crux of the problem, which is, we're talking about better ways of supporting people to make decisions. And I think what you're pointing out is the environment in which this occurs is one in which nobody's taking the time to engage, a patient about a decision, or to know a patient over time, given the constraints. So I think that is a significant challenge that, I don't know if the law can solve that in terms of decision-making law. I think that's a bigger challenge. I don't know if you asked a very good question that I can't really address fully.
Professor Cohn.
Well, thank you all for fabulous presentations. I had a question, thinking about your first takeaway, James, in part in relation to Megan's comments, right? So it strikes me actually your first takeaway is highly radical, right? To suggest that advanced directives not be binding. And I was curious why that was the takeaway, as opposed to the takeaway being that advanced directives should not be triggered in the situations in which you're describing, in which an individual who may have highly unordinary capacity, but can still express a preference with some modicum of understanding, should be treated as an individual whose advance directive has yet to spring into effect, right? Where, for example, the type of supports Megan is talking about would be effective. Is that a better takeaway here? Or do you really want to go so far as to say not binding?
Yeah, so super interesting question. The question of the bindingness of advanced directives is fairly uncontroversial in the United States. They are often thought of here as should be binding, but across jurisdictions around the world, they often aren't and are just treated as influential. So there is a lot of debate in that area. As well, and so I think your interpretation is quite plausible as an alternative way to think. One way to think about what's going on is right. Why isn't the standard of capacity just if you can express a preference at all? Like that should be all that's required. And that seems like it might be intuitive to a lot of people as a way to think about this. But at least within the way that we've traditionally, philosophically, and bioethically thought about capacity, requires more than that, right? It requires an ability to actually think through and understand the consequences of the decision. And you might say, okay, there's like some intuitive support for that idea as well, that we want to have a kind of robust way in which we assess the ability to understand this decision if we're going to respect it. And so I mean, I think you could take either away. Like maybe we should lower the standard of capacity and just change that standard such that anyone who can express a preference in any way ought to be respected. But there might be circumstances under which, and I mean, this is clear from the data, right? People can express preferences, and then people think that we shouldn't follow them, right? Because they're somehow inauthentic or ill-considered, or so I think there is some support in the data for the idea that there are circumstances under which people can express preferences, but they perhaps should be overridden. Which is what I think inclines me to the idea that perhaps advanced directives should be weighty but not binding. But another interpretation, and I think a defensible one, is to rethink the standard of capacity in that regard. Yeah.
Go ahead.
So Ohio has, it's called the State of Ohio Declaration for Mental Health Treatment. I've only had the opportunity to do it with one patient because most of my patients who have like severe mental health issues are, they refuse to take medication, they're not getting treatment. But I have one who, not sure exactly, I think his diagnosis might be inaccurate. He was diagnosed with bipolar and schizophrenia, so yeah, but it goes through, first of all, you choose proxies and the proxies have to consent, which is the first thing. You can choose the doctor that you trust. So this patient chose his primary care doctor. He felt that he can trust her. You can choose mental health hospitals that you want to stay at and the length of stay. You medications that you will not take or do like electroconvulsive therapy, and then I think that was the basic. outline of it. But I wonder, like, so that is something that we already have. There's a space for it to put it in electronic medical records. And I think if there was something like that, that was like for more general medical treatments, right? Like that's not like a living will, right? Because that's not used in every situation, and that's also very specific, but just general medical questions that sort of align with the ones in the mental health declaration. I think that that's like kind of what we're looking for. The only issue is, again, like, when do you do it with them? And I find that getting patients to agree to sign any advance directive can be challenging, but this is a thought I wanted to put out there.
All right, we have time for one more brief question. Aline, sorry. You have about 1 minute.
For an older adult, approximately 75 years old, how do you get out of a bad guardianship?
Well, you.
And who's been like misdiagnosed?
Yeah, so it's quite challenging, but it is possible. You know, I don't know where the particular person is who's thinking about it, but something my clinic does, if you happen to be in New York City. But if you're elsewhere, there are occasionally some legal resources, like often the protection and advocacy organizations.
Like ombudsman?
Ombudsman, or there's I don't know what they call it in Ohio, but there's like a PAMI or PAD, they're called protection and advocacy organizations that are there to provide legal representation to people with different types of disabilities, and some of those organizations do
Like
guardianship
some
work.
of those tests, like
APS would do
local
it.
tests or.
So I think you can probably talk one-on-one, and we will take a break now.